Since no assessment was completed, there can be no demand made. Under such circumstances, petitioner cannot be treated to be a defaulter and consequently notice of demand should have been issued. Since the impugned notices have been issued without there being a proper assessment and contrary to the provisions of the Assam Pet Act 2003, it reveals that there was complete non-application of the mind of the respondent authority. Impugned notices dated so and so as well as so and so are therefore bad in law and therefore set aside and quashed. Writ petition is accordingly allowed in terms of the above. No order is proposed. Under such circumstances, court is disinclined to invoke the powers of the under Article 226 to 27 for issuance of a writ to interfere with the orders dated 11/11/2023 passed by the learned arbitrator in arbitration proceedings numbers and so. Writ petition is therefore devoid of merit and the same is therefore dismissed. No order is to cost. Arbitral tribunal is permitted to proceed with the arbitration proceedings without any further delay. Interim order passed earlier stands vacated. Parties will appear before the arbitral tribunal for appeal. Yes.
I wish to mention one anticipated bill application for listing for hearing on 3rd of September. Another bill application may be also listed on 3rd September on hearing.
Next, please, Your Lordship, for listing criminal petition, Lordship. The next week, Lordship. Diploma.
There for listing, my lord. The criminal appeal 282 in IA 818 already clearly filed and which is listed on 29th of August. But unfortunately, 29th of August, matter listed the Honorable Court before the Honorable Court without the IA. So, Honorable Court given a direction, list the matter fixed on 2nd of September. But 2nd of September, the main cause has come out, but our matter is not listed. The appellant is jail. So, Humble Pair can list the matter in supplementary.
There is already a direction of the court to
No,
list.
Honorable Court was not on 2nd of September. Honorable Court was not available. So, court number 14.
On 2nd of September.
Yes, coming September. So, on that day, as per order, our main cause list, our matter is not listed.
Is there an order of the court earlier
Yes.
for directing a matter to be listed?
Yes, but unfortunately, matter
You take it up with the registry. There is already an order
okay,
for directing the matter to be listed.
with IA.
On the last date, the order was passed in the main appeal.
Main
Right.
criminal appeal.
We direct the IA to be listed. Give the mention memo for the IA.
Yes, sir.
We list it on 2nd along with criminal appeal.
Criminal appeal. Must have.
May I please, Your Lordship, I wish to mention item number 15 and 16. Lordship, consent of the other side, Lordship. In this case, Lordship, MS Dibor going appear in this case. Lordship, she is not well. Lordship, kindly matter fix on Tuesday, Lord.
You have taken consent.
Consent, Lordship.
Mr.
P. Gohai, Lord.
Counsel for Respondent 2, with the consent of the counsel for the petition submit, this matters be adjourned for the day to be taken up on
Tuesday, Lord.
Tuesday. We don't know. These are miscellaneous matters. So let it come on Friday next,
Lord.
6th of September. Yes.
Your Lordship, I beg to mention for listing of a bail application, Lordship, 2nd of September.
Bail. Okay. Yes.
May I please, Your Lordship, I beg to mention for listing a criminal petition next week, anything.
Next week, 6th of September.
Yes, sir. Another press appeal, Lordship, in the next week. It's obliged.
6th.
Lordship, I beg to mention item number 1. Lordship, my senior is not present.
You wait. Wait. No. Yes. Senior not present. Why?
For his personal.
Okay. At the request of Mr. Your name,
A.R. Mondal.
A.R. Mondo, who submits the arguing counsel is not present. Let us hence adjourn for the day. To be listed next week.
Lordship, my senior is like on court number 21, currently passover matter pending.
Passover is, I don't know till the court is there. But at this stage, we are only issuing notice. What else?
Lordship, I am praying for an interim stay of the
Stay of,
proceedings before the learned CJ, Lordship. It was
the order, when was the order? This is an order rejecting your application requiring sanction. Praying for sanction.
yes, and they have been petitioners have been directed to appear before the court
On which date?
on the 6th. Lordship.
Let
Sorry, on 3rd, Lordship.
third of,
On 3rd of September.
3rd of September.
It should have been
3rd of, it says 8. They have already appeared, I think.
no. Lordship. The next date is initially it was on Lordship 3/8, but the next date is fixed on 6th of September. Lordship.
Yes?
Which one PA for appearance?
No. 3/8 is already gone.
That's
Next
what
date.
Yes.
It's next week.
Next date, Lordship, I'm
6th.
not having any
Sixth.
instruction. I'll
It says
take
it
it.
is 6.
Lordship, let notice be issued, Lordship. At that stage, Lordship, stay may not be guaranteed, Lordship.
No, this is,
Because it's,
Lordship, this is my petition. Therefore, Lordship, the grounds here, if I may take your Lordship to the arguments which was projected before the learned CJ by the CBI. I'll take your Lordship to that part of the order, Lordship. If I may take your Lordship to page 107 for a moment.
Yes.
The paragraph below.
Yes.
During the course of hearing, Sri R.C. Basumatari, Deputy so-and-so, to the learned additional PP Bhima Hasav, Sri so-and-so, file petition, it is and prayed for informing and asking the army authority as to whether they wish to opt for a court martial in this case or allow time to the CPI to take steps to obtain prosecution sanction. Now, I would refer to their manual, the CBI manual. Now, what does the CBI manual say? As per the CBI manual, Lordship,
They have been asked to appear before which court? Special
before
court?
before the learned CJ. Now,
CJ.
the CBI has to take a sanction before it is as per their manual. They have to take a sanction from the concerned authority, and thereafter, only thereafter the proceedings will go. I am only on the part of sanction, and it is their petition which they have filed, and in fact, that has also not been.
Who filed the petition? You filed the petition. CBI filed the petition
CBI filed a petition.
for sanction.
Lordship, from the order it reflects, Lordship. But the question is whether sanction is required or not, Lordship. Whether the act has been done in discharge of his official duty. If it is not,
We
Lordship.
are asking you one simple question. Who filed the petition 1023?
That
Page
was
number
from the
41.
CBI.
Page number 41. Filed the petition.
No. Page number 41 is, Lordship, our
It is
petition.
their
This is our petition.
Ah.
Now, I am taking your Lordship to page number 107.
By which this petition was rejected.
petition.
What is the prayer here in this petition?
In the instant petition, Lordship, the criminal petition, we are asking for a
No, in this 1023,
1023, Lordship, we made a petition before the Honorable Court that the court cannot proceed without a prior sanction under the Armed Forces Special Powers Act. In fact, by 107, the CBI has also filed a petition, that was petition number 81 of 23. If your Lordship will come to page 107.
Hmm.
Prayed for informing, asking the army authorities as to whether they wish to opt for court-martial in the case or allow time to the CBI to obtain prosecution sanction. Now, that has also not been allowed. Now, as it is, Lordship, the law is well settled that without a prosecution sanction under Section 6 of the Armed Forces Special Powers Act, the court will not take cognizance and proceed with the matter. And there is a host of judgments, Lordship, right from the Supreme Court and our court itself.
do you have a copy of that act? Armed Forces?
Yes,
Special Powers?
yes, yes, yes. Yes. Lordship will come to Section 6. And I'll trace also the way how the CBI has to proceed by their own manual.
Where is that order declaring these areas to be governed under this
Lordship,
act?
Annexure 1.
Annexure 1.
And that has been subsequently extended. I've got a list of the extension of the extensions, but this is the primary notification. Thereafter, it has been extended from time to time.
Where the incident took place in Haflong.
In Haflong.
This includes six schedule areas also.
Yes. For the whole of Assam. And if I may place, Lordship, how the CBI has to proceed is from their manual.
When did the incident occur?
2001.
2001. What was the status then?
It was still a district.
Are you sure?
Yes. Now, CBI manual, Lordship, I have taken a extract of the prosecution part. Lordship will come to page 360. The page number is below. I'll be referring to 20.36.
Yes.
CBI report and sanction for prosecution in cases involving army personnel. This is precisely under these provisions that the application was filed before the learned CJI. If I may read, Lordship. After examining the subject matter in length with the law officers as well as officers of the Director General, Discipline so and so, the following instructions have been issued for compliance by all CBI heads of branch, ranges and zones. Additional Director General, Disciplinary and Vigilance, Adjutant General's branch integrated so and so is the nodal authority in respect of prosecution, disciplinary matters of all army personnel. Therefore, CBI branches, while sending the CBI report requesting for sanction of prosecution and request for documents, etc., to be concerned to the concerned army authority, shall also send a copy of the CBI report to the Additional Director General. CBI branches shall ensure that the CBI report being sent to the army authorities, including so and so, is complete in all respects and contains the necessary enclosures. The branches shall keep in mind that court-martial proceedings under the Army Act is akin to proceedings in ordinary criminal court, section 345, 346 CRPC. Under the Army Act, RTA, major proceedings are also the proceedings there during the court martial. Hence, the recommendation for simultaneous prosecution and RTA major is liable to be hit by double jeopardy and has to be avoided except where RTA minor is recommended. The Army authorities may prefer to initiate court-martial proceedings under Army Act where CBI investigation results in prosecution or RTA major of only Army personnel. Where the RTA minor is proposed against Army personnel,
this matter was committed to CBI court
No,
earlier.
it was
Yes.
submitted to the CBI court and CBI court said that it did not have the jurisdiction.
Why?
No, and it was sent back.
Okay. Okay, we'll issue notice at this stage. Heard Mr.
Lordship,
Harshidi
please don't
Chaudhary, learned
interrupt.
counsel,
Please till the
appearing
next
for
day,
the,
Lordship.
you are appearing as a DSGI.
Lordship, since it is an army matter, Lordship, PSG, otherwise I've got a wakalatnama.
Appears for the petitioner, Mr.
M. Hello,
M. Haloi appears for CBI.
CBI.
The criminal petition is directly against the order. 29/06/2024. Passed in PRC 81 of 2022. Case number RC 03 S 1006 SIL by the court of CJM Dimapur.
PGM,
CJM
PGM.
Dimapur by the impugned order Colonel CJM upon examining the court and upon consideration of sufficient data concluded rejected the petition number 1023 filed by the present petitioner, praying for a direction of the CBI to obtain sanction before praying for a direction to praying for appropriate directions to the CBI to obtain prior sanction before proceeding with the matter. So, said application was rejected on the grounds and reasons mentioned in the order. The Colonel CJM Mahatau concluded that in the facts of the case, it did not require prior sanction for prosecution as
Lordship will come to page 109, bottom paragraph. The learned court has already come to a conclusion. The CBI cannot,
it was held that the alleged incident was not done or purported to be done by the accused person in discharge of their official duties. So, the learned counsel for the petition that the impugned order is contrary to the law laid out by this court as well as by the apex court, as well as to the provisions of the CBI manual, clause 20.36. So, it is further submitted that as per the Armed Forces Special Powers Act 1958, Section 6 prohibits any prosecution, suit, or legal proceedings except without the prior sanction of the central government in respect of any person, in respect of anything purported done or purported to be done in exercise of the powers conferred under this Act. Learned counsel submits that notwithstanding the statutory provisions as well as the law laid down by the court, the Learned CJM Mahasau proceeded past the impugned order ruling that prosecution sanction was not necessary, as the alleged incident was done or purported to be done by the accused person in discharge of their duty. He submits that the next date fixed is 3/9/69, on which date the petitioners are directed to appear before the court. So, Vera. Mr. M. Halloway, learned counsel appearing for the CBI, strongly objects to the praise made. He submits that at this stage, prima facie, it appears that the impugned order was passed by the learned court of CBM by taking into account all the attending facts and circumstances and is not violated of any of the act or the law as contended. He therefore the court may issue a notice at this stage permitting him to complete his instruction, file necessary objections, seems to advise the speaker. Accordingly, let this be issued. Returnable 3 weeks.
Lordship.
Mr. Halloway appears accepts notice on behalf of all the respondents. And such is the way by extra copies be furnished within 3 working days from today. So, heard also on the prayer for stay, to notice the prayer for stay. Returnable on 20 September,
Lordship, I may be protected.
20 September.
Fixed is the next date. Lordship.
We are asking you, returnable 20 is convenient for you or not? Yes, all right, 20 September. Till the next date fix, further proceedings in so and so act, in respect of the order and proceeding shall remain stay.
So, like,
Registry to call for scan copies of the records of the so and so by the next date fix.
Hello.
Yes,
Let me do it. मतलब 482 मतलब picture मतलब under TNSS मतलब then मतलब picture lordship मतलब is a circle officer मतलब he has been unnecessary track मतलब in the dispute between the मतलब the project Samata
where is the FIR?
FIR is a page 13 मतलब
30,
13 1 3 मतलब
1 3.
मतलब it's a little bit long मतलब in fact मतलब pertaining to the governing body of the Create College मतलब the petition is still pending मतलब 2 petitions मतलब now मतलब it is a counter outpost मतलब of the earlier FIR मतलब and he may have read the FIR मतलब
Page 13.
मतलब
Where is your name here?
मतलब my name मतलब it is
You are named in the FIR.
yes मतलब we in the High Court order JP the circle officer Paschim Nalbari Arpana Sharma to deposit the passbook checkbook of the account number so at the Belfast police station.
You're reading from where?
मतलब
May I submit? If Lordship kindly come to page 13,
Hmm.
last portion Lordship, 6th line from bottom Lordship. As such, it is not clear.
Yes, sir. Not
Yes,
clear.
as such, it is not clear as to how the aforementioned withdrawal was made possible without any such order or resolution, and when all the passbooks, checkbooks of the account number so and so are under the custody of a police station, Dr. Torun Chandra so and so, who gave resignation but illegally so and so one and so and so are perpetually self-tax president and secretary of the newly formed governing body of so and so, whose legitimacy is to be distressed by the Honorable High Court, are in connivance with the bank official as well as the then circle officer of Paschim Nalbari, namely Aparna Sharma. This is the petitioner. Have misappropriated the said amount.
मतलब kind of come to page 23 मतलब as per the decision measure before that matter kindly have a look at the decision measure actually there is a resolution of the governing body measure subsequently the governing body as well as the measure the informant measure the some of the project has decided to deposit all the checkbook and passbook to the Belfast police station measure this is decision measure I have submitted now measure now kindly come to page 23 measure in the affair measure they have the informant himself had stated that the account has already been frozen matter.
Page number
Matter page number 13 matter itself matter.
13.
Matter
FIR.
13 matter.
Yes.
Matter if I read the matter complete matter, then it will be some clear matter. The middle portion matter.
Where is the petitioner now?
Petitioner is outside matter. He's circle officer.
Posted where?
Nalbari matter. Paschim Nalbari circle officer. Revenue circle matter. And kindly come to page 23 matter. these are the type copy, my lord, and vernacular will find, my lord, from page 29, my lord.
Is there any other bail matter in respect of this?
Yes, my lord. Bail matter, my lord, yesterday, my lord, the accused number 2 and 3 had filed a application for anticipated bail before the additional session judgment, Nalbari, and they were allotment.
Where is that order?
My lord, I could not collect the certificate copy, my lord, but my record statement may be recorded, my lord.
All right. Heard. Counsel for the
And it is the outpost.
anticipatory bail. What is the term used now?
Outpost, my lord.
Pre-arrest.
Bail, my lord.
Pre-arrest. The bail petition is filed under section 4A and BNSS 2003. Apprehending arrests. Connected with Elsor use case number 98 of 2024. under section 3. So, ERA, an FIR was lodged by the secretary of
In fact, he checked it.
Project Tomota Educational Society, Tomota, making certain allegations against certain person with respect of handing over or withdrawal of handing over of checkbooks, passbooks, and withdrawal of funds of the account maintained and standing in the name of the state society. Stop. The present petitioner at the relevant point in time was the circle officer in Tomota,
Postim Nalbari Revenue.
Team Nalbari. And the reference is made in the FIR. So, the present the learned counsel for the that petitioner is an SCS officer and presently posted as circle officer in
Postim Nalbari Revenue.
same
Same.
office.
Same.
Working same Nalbari. So, subject that petitioner is not connected with the alleged offences, and the dispute is primarily between the informant and the former
Governing.
bearers who named the there. So, it's up that since the petitioner is a government servant, if the protection of free arrest bail is not granted, it's likely to suffer severe prejudice and severe prejudice. Mr. B. Sharma, current VP, submit that PD is necessary at this stage. So, having heard the CDP call for, is there anything else you require? Only CD.
Only
CD. Meanwhile, the petitioner is arrested in connection with released on furnishing a bail bond of rupees 15,000 with 1 local security of like subject to the following conditions.
Right.
It shall not leave, shall appear before the IO. He or she
She, ma'am.
she
She.
will appear before the IO within 10 days from today and shall not attempt to with or use it. Move out of the jurisdiction of the IO without intimating the IO. Let the matter be filtered on
18/9.
18/9.
I am obliged.
May I please the Lordship?
Yes.
This is pre-arrest bail application, Lordship. FIR Lordship, final page 13. Actually, dispute between two roommates because of rent and all. There was some scuffling between
1-3.
1-3. Some dispute between the two roommates, Lordship. They used to stay together because of some because of pending rent amount. There was some dispute because he wanted to leave from the room. So there was some kind of scuffling. As a result, 325 is there. That's now new section is 172. Only non-available sections are Lordship is 307 and 380. Those two sections are not attracted in this case because
No, but
307 and
307 is not here.
That is now 1091 DNS
109.
1091. That will not be acted in this case. And so far 380 IPC is concerned, that is now it has become 305 DNS. The rest of the sections are all billable. Only these two sections are non-billable. That's how we have come before your Lord.
109.
1091 bracket 1
Then
and 305. These are the two sections which are non-billable.
30.
Rest of the sections are billable. 305 is 380. That is stealing articles. He has taken his own articles from the room lot. That's why he has added 380. On belonging, he has taken.
Yes. Heard. That's anticipatory bail petition by the petition that we have requested that the fire dated so the vote by the informant. One three Akash dated Ravi. So, the seat fire has dispropriate rate 13 of 4 on a council for the of the BFI. There are allegations made taking away some amount from the health as well as other articles from the
From the room where they are staying.
no, this belongs to the informant
No, they are stayed in a rented house.
from the room where which was shared by the informant and the
Active.
present petition. So because of certain differences, stuff broke out and realized that the informant suffered injuries with that. Senate Council for the Carolinas. It is the difference of misunderstanding between two persons staying in the same, sharing in the same room, and all the allegations made in the FIR are not correct. It is not correct. Okay. So, consequently, he appears arrested of the FIR law. That is for Mr. Richard Mother, the CDS report. According to the CDB court, when arrested in particular, is recently released on permitting a bail for 50,000 in one. Like he's from Guwahati.
This is from Johan.
Jorhat.
Another thing, Lord. One section we missed out, that is 351 to IPC, that is 506 IPC. That is also available, but somehow inadvertently missed out in that.
One local security of like amount. Of the arrestee. Subject to the following conditions will appear within
1 week. 1 week.
Before the I.
That
1990.
we give, say that section we added, we made 351 to, that is 506 IPC.
The council for the petitioners subject to the court that by oversight he missed out one particular section in the
351
translated copy. Where in the
It
translated
is in page 16, 15 you'll also will find in the left side.
page,
Page 15.
what is the section?
Section is 351 bracket 2. That is 506 IPC.
Yes, 350. That while submitting the translated FIR, one of the sections was inadvertently not added. Is 351 within bracket 2. Submit that may be permitted taken in the court record. Considering the submission made and not objected by the other APP. APP, any objection?
No.
The corrections be carried out in the presence of the court. Next on
1990.
19. Much.
19 already.
Move the lordship.
My lord, this is an application for PRS bail, my lord. The FIR is at page 10, my lord. Respectfully, I beg to state that on 18/8/2024, my son, Rohul Amin, aged 15 years, came to the house of his maternal uncle yesterday.
Under what section?
My lord, sections are, my lord,
Attempt to murder is
294, 109,
Where do you find it?
my lord,
in the first title.
false title, my lord. Your
But in the FIR, it's not there.
It is there, my lord. It is registered, my lord,
Ah.
at page 13, my lord. Received and registered BOCO PS case number, page 13 at the bottom, my lord. 296, 109, 11 to 74. Your lordship may kindly see the contents of the FIR at page 10. All these sections are in fact not even applicable here, my lord. While my son was playing carom on the road near the house of the accused person abused my son with slang words and pressed his neck by lifting him on the air and caused grievous injury on the left hand. Having seen the occurrence, my mother-in-law, Karimunnesa, came forward, which the accused pushed her and torn her clothes. This is the only allegation, my lord, and this is totally false. In fact, the petitioner is an elected member of the Gaon Panchayat, my lord. And all this FIR was not only, my lord, out of political grudge, my lord, to malign him in the society only. This is the only ground, my lord. And so far as section 11.2 is concerned, the ingredients of 11.2 is not at all there, my lord. 11.2 is solitary confinement. So there is nothing in the FIR regarding the solitary confinement. And attempt to murder, that is section 109.
Attempt to murder and outraging the modesty.
This is not, this is,
70.
she is an old woman, my lord. She only went there to my lord, and he only pushed her, my lord. So there is no question of outraging modesty here, my lord. She is the mother-in-law of the informant, my lord.
We heard
In the vernacular also it is written only pushed her, my lord.
apprehending arrest, therefore it's connected with the FIR dated 2008 by the informant. Pani Sood.
The fire was also lost the next day evening, my lord.
Making allegations against of causing grievous injury on the left hand of his son, as well as attempting, as well as uh, physically assaulting the mother-in-law. The FIR was received and registered as section 96 slash 109 slash 11 to 11 within bracket. Apprehending arrest.
74 also.
Sorry.
74 also. 11 2
Oh, I thought it was struck off. 74.
Yes, sir.
It looks like it was scribbled out. No. From page number 13.
But they have stated it is
70.
there.
Page number. When it comes to that is the call. No such according to the CDB invite the meantime. The event of the arrest. Sorry. Peace. IO within 7 days from today. And its bail is subject to the following condition. And when can you produce? 19th.
My lord,
So
medical report also.
Huh?
Since the allegation of injury is there, so medical report may also be.
The along with medical report we got 99.
Favorable, your lordship. My lord, may kindly say FIR page 8. Allegation is serious,
Areas.
that is 376 is there. Rest two sections are available. But my lord, the thing is this, my father was the mediator of the marriage of the girl, of the
Let us-
woman, man.
Let us call for the CD along with medical report.
Okay.
Then we'll consider your prayer for bail.
Okay.
Within a short.
Here, my lord, there is a village meeting.
Hmm.
In village meeting, kindly see page 15. What are the villagers, including Gaura? She filed a petition before the village, Gaura, village man.
Hmm.
That is her petition is page 15. Mirza Khatun first party, second party, Momin Ali. Momin Ali is her husband.
No, whatever it may be, there is an FIR with serious allegation.
Yes,
So therefore, let us call for the CD along with the medical.
shorted
Heard,
absolutely
review,
false.
APP, state, petitioner is before the court, bring for clear state, apprehending arrest, FIR dated 4/7/2023. Registered as Cobra PH case number 154/2024 under section case number 9. So, let the CD along with medical report be called for. Prayer for anticipatory bail to be considered upon perusal of the CD and along with the medical
On the next day.
on the next day. Please note
10-9 Lord.
10.
All right.
10.
May I please, this criminal petition lordship, and this case lordship is only, case is still against the petitioner lordship, only 2 dates lordship. One date is absent lordship, and we will find page number 20 lordship. And NBW issued lordship, and the petitioner and the informant, they have already talked.
We dispose it of directing you to appear
Lordship.
and file necessary application.
In the
And
meantime,
if such application is filed, will be considered keeping in view the law laid down by the apex court in
otherwise,
Siddharth.
NBW may be state lordship, otherwise.
No, NVW will be state till you
Lordship.
appear and file the
Lordship,
application.
lordship, will appear.
Right, heard. Court for washing of the non-bailable order of arrest issued by the court of SDJM Sodor Corbetta in connection with NI case number 60 of 2020. Submitted that you did not appear on 2 days.
One, lordship, one date, lordship.
Why did you not appear?
Lordship, and as per the lordship, the instruction lordship, and he engaged, advocate was concerned, lordship, and informed he was out of station petitioner, but the engaged advocate was taken step lord.
Hmm?
And engaged advocate of the court below lordship did not take step lord, but informed was by the petitioner.
Submit that on the date fixed, the concerned counsel was engaged by the petitioner did not take the step according to the court. The competent court proceeded on bail warrant arrest by order dated 26/7/2024. The matter is fixed on next date for appearance fixed on 3/9/2024. So, the Sharma appears of the state. Whereas, considering the limited prayer by the petition, because of the matter can be disposed of at this stage without being just. Petitioner will appear before the court on 3/9/2024 and file necessary application before the competent court. So if the court, so if the competent, if any such necessary application by the court, the same shall be considered by the court, keeping in view the law laid down by the effect court with regard and others, and would not proceed to detain the petitioner unless for reasons determined as found by the court, as found by the competent court. If petitioner has directed appears before the court on 3/9/2024, the NBWA issued on 26/7/2024 shall not be enforced. So, if, however, the petitioner fails to appear before the competent court or fails to take proper steps as directed, so the command, the NBWA dated 26/7/2024 may be enforced without further reference. Criminal petition accordingly stands disposed of.
Ablash.
Net. This revision petition is against the judgment and order that is annexed as Annexure 14 in this petition. So what happened in this case, my lord? On 5/4/2022, my lord, and in fact, there is a DV proceeding between the parties. The petitioner is the husband, and the respondent number 2 is the wife. So before going into the, my lord, the order impugned herein, my lord, your lordship may kindly be pleased to peruse page number 107.
Yes.
So this is the impugned order passed on 5/4/2022, whereby yes, interim was granted to the wife.
You are for?
I am for the husband.
Yes.
I am for the petition.
What was the interim order?
Interim order was that, my lord, page number 107, my lord. The petitioner was directed to pay a sum of 3,000 per month as interim maintenance. So when the, my lord, the application was filed under section 12, my lord, of the DV Act, the same was recited by the petitioner by filing a written statement. And the specific plea of the petitioner was that, my lord, the petition was not maintainable because the petitioner raised the question of maintainability of the proceeding before the learned court below. Inasmuch as, my lord, the respondent number 2 was not the wife of the petitioner at that relevant point of time. And moreover, my lord, the respondent number 2 also did not reside in a joint household, my lord, in the place where she has alleged to have resided with the respondents. That was the specific plea. And therefore, this prayer was that, my lord, till the matter is proved by producing evidence, my lord, no interim may kindly be passed. But that part was not considered, my lord. The interim order came to be passed. And if your lordship is pleased to peruse page number 108, my lord, that part would reflect the observation of the court that justified the, my lord, passing of the interim order. May I read, my lord?
Yes.
Now, my lord, in the earlier paragraph, the court says that I have perused the petition, also the written statement, assets and liability. Now, at this stage of deciding the prayer of interim relief, the court needs to see whether a prima facie case is made out. The record explicitly reveals that the aggrieved person had been in domestic relationship with the respondent in a shared household as defined under the DV Act. The respondent number 1 has admitted the marriage between him and the aggrieved person in his written statement, and it is also admitted that a son was born out of the wedlock. It is also prima facie proof to the satisfaction of the court that the aggrieved has been a victim of domestic violence by of physical, mental, financial, and emotional abuse at the hand of the respondents, for which presently she is living separately with her minor child without having sufficient income to subsist themselves. That is the observation where the court came to the conclusion that it was clearly established in the opinion of the court about the domestic violence. But if your lordship is pleased to produce both the application filed by the respondent number 2 as the wife, my lord, and my lord, the written statement submitted by the petitioner, my lord, the allegation of being in domestic relationship also stands disproved, and that she also failed to produce any evidence or at least prima facie, my lord, materials that
You were never married
I married, my lord.
with the respondent?
I was married, my lord, earlier.
You were married.
Married, my
To be listed again on 20 or 18, it will be 18 September, by which date the respondent will file the objections, if any. The councils will also apprise the court if any proceeding under 125 was carried on between the parties and whether any, if any, orders have been passed in such proceedings by the next 8 weeks.
Obliged.
Lordship. 430 application lordship. FIR is at page 9, lordship. Counterblast FIR lordship. Earlier we have filed our FIR. Later on they have come lordship. An attempt was done to, as per allegation lordship, attempt was done lordship. To have higher lordship. Page 9 is the FIR.
CD available.
Yes, Lordship.
Where is the FIR?
Page 9 lordship. FIR against me lordship. Made it FIR. On page 16, the affair is filed by us against the informant and his family members. Page 16, lordship. We have filed our affair earlier, lordship.
What has happened to this bail petition?
Which one?
In this, you have not filed a bail application. Page 16 FIR.
There is the affair was filed by us Lord, against the informant.
So is there any bail petition pending against this FIR?
No, I don't think
I
so.
do not have
Lordship.
knowledge. Actually, lordship, the
Mr. Sharma?
No, Lordship. Lordship, what I have gathered from the case day, Lordship, the FIR lodged against him is true, Lordship, because he has suffered injury on his private part, Lordship. And one bail application was also prepared in the court below, Lordship. There also the case was dismissed, Lordship, with bail application was rejected.
Filed by him.
Yes. And Lordship, there are eyewitnesses also who have heard hue and cry raised by the
No,
victim.
that's okay. I am asking you that there is a subsequent, he has filed a,
Yes, yes,
as per my
no,
instruction,
his
lordship,
wife has filed an FIR.
Lordship.
as per my instruction, lordship, the lady was arrested, lordship. She was sent to jail and she was released, lordship.
Huh?
That lady, lordship, that who cut my private part, lordship.
Huh.
That lady.
So there must be some bail
Yes,
application
yes.
available.
From the case that he has surrendered before the police station, Lordship.
Okay.
That is there.
So when the attempt only done, lordship, as per allegation, lordship. And you also kindly see, when I was coming from my place of work, the informant and his teams lordship took me inside their car. Their car cut my private part, lordship. And I have clearly mentioned in my FIR, lordship, it is filed by us earlier,
Not
lordship.
a case for anticipatory bail.
Okay, one more submission.
Not a case for anticipatory bail.
And I was admitted in the hospital also, lordship.
You may have, because of your misdemeanor,
No, actually, lordship, the actual fact is that, lordship, when I am coming from the place of work, lordship, they took me inside their car, lordship. Therefore, they have cut my private parts.
that why? Why will they injure you? They may injure
My
you.
lord, there is some rivalry,
Your
lordship.
health.
But there are some rivalry because of some boundary lines, lordship.
Lordship, one more submission, Lordship. The FIR was lodged on 6/4/24. This incident is of April. 24. Now, Lordship, subsequently, Lordship, on 25/7/24, the victim was harassed by the petitioner and their family members, and she lodged then written petition before the SP Dorong Lodge. That is also in the case that the family members of the petitioner are continuously harassing the victim to withdraw this case. The allegation is serious. That is, 164 also recorded, Lordship. He has specifically said, yes, yes, yes.
That is 164.
Yes, yes. Clearly implicated. Sir. Neighbor statements are also there.
Clearly implicated.
Yeah.
376 does not come, Lordship. Only attempt was done as per allegation, Lordship. And what they have done, Lordship. I was admitted in the hospital, Lordship, for that reasons, Lordship. I was in for 3-4 days, Lordship, in hospital, Lordship, Narayana Hospital, Lordship. I annexed the documents, Lordship.
Is that the stage of investigation?
No, since May, Lordship, this case is pending, Lordship.
Hmm?
Since May, this case is pending, Lordship.
Is there a medical report here?
No,
For the victim? No.
he is on the run, Lordship. Medical report cannot be.
No, no, no. For the victim.
No, no.
But there is no allegation of, there is no evidence, prima facie, to offense of 376.
Yes. Attempt.
Only attempt, Lordship. That cannot be 376, Lordship.
But it's Lordship, the other factors also, Lordship, that his agents or whatever we can call it, Lordship, they're repeatedly trying to threaten the victim. Lordship will find the complaint in the
Lordship,
First
no, Lordship,
stages.
I am not in the local area, Lordship, due to police harassment, Lordship. I am outside, Lordship. Police may arrest if I remain here, Lordship. Tell is page 24, Lordship. My medical report, Lordship.
So there is no doubt that you are injured. Therefore, you have made these allegations.
Lordship.
There is no doubt.
Lordship.
But why would somebody cause an injury to you like that?
No. Well, there was a rivalry, Lordship, business rivalry and boundary land, Lordship. And 370 does not come, Lordship. Only attempt, Lordship.
The other sections can be added during the investigation. Appropriate sections if required. Matter is under investigation.
Well, kindly consider my health condition also, Lordship. 4 or 5 days in the hospital, Lordship. And the during some rivalry, Lordship. they have done this lordship, and we have filed our FIR earlier lordship. Thereafter, later on they have come, they have filed this FIR lordship. Counter plus FIR lordship, this is. My FIR is, please,
Attempt is also serious, lordship. Otherwise, attempt is also carries the same punishment, lordship. Attempt.
earlier, in earlier, no.
The locality, and previously, my lord, 2 FIR
Where,
also
where
filed.
is the FIR?
Well,
first?
impugn FIR, my lord, annexure 3, my lord. 21.
21.
Yes, sir. Here, my lord, as per my lord allegation, one blow was inflicted on the face of the my lord husband of the informant, my lord. Here, my lord, our my lord, humble submission before your lordship, as per my lord instruction, my lord. Actually, they both are my lord closely related persons. My lord, actually, both families are my lord from the my lord brother and sister, my lord. These two parties are my lord from the children of brother, and another party is my lord children of another sister, my lord. Close related. But here, my lord, both the parties are my lord not so seriously fighting. But in the middle, my lord, this man, husband of the informant, became serious, my lord, and he picked up my lord deadly weapon and tried to my lord kill the people of that side, my lord. Therefore, my lord, his own person, my lord, with a my lord bamboo piece, my lord, to prevent him, my lord, inflicted one blow on his face, my lord. Therefore, by this, my lord, bamboo piece, my lord, one cut injury he sustained, my lord, and therefore he came back, my lord, and he could not murder any other person, my lord. Otherwise, his intention was so dangerous, my lord, he tried to kill more people, my lord. Though, my lord, one person, my lord, father of the petitioner, was already killed by him, my lord. This is our instruction, my lord. And for the appreciation of by your lordship, my lord, I have also annexed, my lord, his injury, my lord, his photograph, my lord. Lordship may be pleased to see his injury, my lord. Already cured, my lord, when he was arrested, and photograph was, my lord, published in the official, my lord, social media, my lord, by the police, and we downloaded this photograph, page 45, my lord. One small cut injury on, my lord, if, my lord, minutely seen, it is seen there, my lord, one cut injury on his nose, my lord.
He is the husband of the petitioner.
Informant, my
Informant.
informant, my lord. And our, my lord, specific stand is that, my lord, had this my lord, injury was not inflicted by his own, my lord, family people, he proceeded to, my lord, kill more person of our family, my lord. And, my lord, all are educated.
What is the stage of your FIR?
Well, our FIR, my lord, is still under investigation, my lord. My learned friend also received the, my lord, case diary. But so far, my lord, our FIR, it is charged, my lord. And FIR filed by them, my lord, against us, my lord, we are paying bail.
Who filed the second bail petition?
Second one, same, my lord, family member.
Same family.
Family member. They are, my lord, educated, and, my lord, they are, my lord, job holders, my lord, and students. Therefore, it is separately filed, my lord. Lordship, kindly have a look, page 47. He is a government employee, my lord, petition number 1. And, my lord, page 48, he is a pension holder, my lord, petition number 2. And 3 and 4, my lord, they are respectively, my lord, student of the university, my lord. 49 and 50, my lord, they are admit card of the examination. It is a very unfortunate incident, my lord, and here, my lord, one relative, my lord, police personnel, my lord, he is, my lord, twisting the entire investigation. Therefore, my lord, as per, my lord, our instruction, though it is not, my lord, proved, my lord, but he, my lord, case where from, my lord, our innocence will be proved, my lord. He already got, my lord, charged our case, my lord. And their case is, my lord, which is, my lord, lesser with the punishment, or this is still under investigation. And even, my lord, this policeman gone to that extent, my lord, he is, my lord, know the procedure. Actually, this man was died on the same day. But managing, my lord, hospital, he kept, my lord, in the hospital, my lord, to show that it is subsequently died, my lord. when my lord, he was, my lord, brought my lord to the home, my lord, for my lord, last righteous, my lord. It is found, my lord, already my lord, insect are, my lord, full of, my lord, his body in insect, my lord. So therefore, my lord, they are to that extent, my lord, they are manipulating the investigation. And our case is serious, my lord. It is already charge sheeted, my lord. Their case is not yet charge sheeted, my lord. Even, my lord, police has written that, my lord, in the charge sheet, my lord, CD, my lord, there, we, my lord, started fight part, my lord. But in our, which is already charge sheeted, there is a full proof is there, my lord. They started fight with us, my lord. And our man is killed. Even lordship, with all respect, my lord, I beg to submit before your lordship, assuming, my lord, the man who, my lord, killed a person and he sustained only small cut injury on his nose, my lord, already secured and he is in jail, my lord. My lord, therefore we are before your lordship for this injury, my lord. Only one injury, as per medical report, my lord, it is a sharp weapon, my lord, and simple and grievous, my lord. But as per our my lord, submission, my lord, this is as per my lord, medical opinion, my lord, it may be, my lord, grievous. But as per our, my lord, legal jurisprudence, my lord, this cut injury as per section 320 will not come under the, my lord, grievous injury of section 326, my lord. Because for such injury, my lord, at least 20 days he should be in hospital, my lord. But he hardly, my lord, 4 or 5 days he was in hospital.
Here, it is very simple. Two cases are there, Lordship. One they have filed, one file against them. The one which they have filed has already been charged according to them, because Lordship, there was 302 was later added on because one of the victims, who happens to be the father of the petition number 1 in item number 9, Lordship, he died, Lordship. So 302 was added and they were all arrested. Now, Lordship, regarding the statement that they have inflicted injury on one person whose nose, they are saying that simple injury, Lordship will kindly look to the photograph, what has happened to the victim, Lordship. And their Lordship, altogether there were 4 victims in the case in which FIR they have come against Lordship. Here, one of the victims, he has suffered cut injury, sharp cut injury on his nose, Lordship, which is grievous, sharp, and he was thereafter referred to higher hospital, Lordship. Second person, Lordship, Abu Jahan Muzumdar, he suffered simple blunt press. Third, Lordship, same simple blunt press. Now, Lordship, they were granted interim protection by the court below, Lordship. Thereafter, perusal of the medical reports, their bail was rejected. They once filed this bail application before a coordinate bench of this High Court, Lordship, where, Lordship, after perusal of the medical report, the court was going to dismiss the petition.
No, my lord, it is wrong submission. My lord.
Oh, let him
submit.
Let him submit. You'll get your.
Their Lordship, when the Honorable Court was just going to dictate the order to dismiss the petition, they withdraw it, Lordship. And they have not mentioned this in this petition also, Lordship.
Mention, my lord.
Now, Lordship, no, they have not mentioned all these facts, Lordship. Now, Lordship, what has happened? If Lordship kindly goes to the photograph, after that, Lordship has nothing else. No doubt, one person has died, their father has died, Lordship, but it was a group fight. Both parties sustained injuries, Lordship. And this nasal bone fracture, Lordship, he had to go underwent century. He had to insert plates on his nose. He was in hospital for probably 8 or 9 days, Lordship. The injured person.
This is the same person whose photograph is there.
Yes,
Yes, same person. He is saying that it is a simple nose injury.
You only injured the nose.
Yes, my lord. And my lord, our, my lord, humble submission is that, my lord, this injury, my lord, by their own people, my lord, to prevent, my lord, because he has become so serious, my lord, and started to assault, my lord, with dark weapon, my lord. Prevent, my lord, one, my lord, half piece bamboo, my lord, inflicted one blow on his face, my lord, not to proceed further. My lord, this is our, my lord, submission, my lord, and we have stated also, my lord. And my lord, earlier bail application, lordship, I have to show, my lord, some document received, my lord, page 28 and
What is the
36.
stage of investigation now?
Yes, my lord.
Lordship, it is pending for their arrest, Lordship. Otherwise, witnesses are there, Lordship. Eyewitnesses, statement of the injured persons are there, Lordship, whereby they have implicated all these family persons.
My
They
lord,
fought in a group, Lordship, And because of those five lordship, one person died from their side, and the other side sustained 4% sustained injury, including one person lordship who had suffered grievous injury. He was admitted in hospital for 8 or 9 days. That is there.
Only, my lord, murder or my lord, sustain one simple injury, my lordship. Two, my lord, show two other FIR from the locality. I have annexed, my lord, page 28 and page 36, my lord. He is a very dangerous person, my lord. Once, my lord, he, my lord, attempt to murder his father also, my lord. And father, my lord, give charge to him, my lord. One day we will be killer and murderer. And now, my lord, he has become really. Page 28, my lord, this man, one FIR against him, my lord. Ilyas Ali Majumdar, this is the killer, sustained injury, my lord. And page 36, another, my lord, FIR of the locality, my lord. He is a very well ferocious person, my lord. And I am, my lord, honestly saying, my lord, this is the fact, my lord. This injury was inflicted by his brother, my lord, to prevent him, my lord. Otherwise, he went, my lord.
There is no doubt that you
Yes,
are honestly saying it.
Yes, my lord.
The question is, you have been instructed, whether the person who instructed you, whether it
Yes,
was
my
done with all honesty.
Yes, my lord.
And lordship,
And my lord, this is the conduct, my lord. And my lord, this injury
We
is.
will, you get up-to-date CD.
lordship,
We will grant him interim.
lordship.
You appear before the police, get your statements recorded, get us an up-to-date CD, then we'll decide.
And lordship, in item number 9, why they have not mentioned that they have earlier prepared one bail, anticipated bail application?
No,
which was
mention, my lord. Lordship, kindly have a look. I have mentioned on page 9, my lord. My learned friend, my lord, missed, my lord, this paragraph.
So now that is irrelevant because we have a system by which whatever
Yes,
bill
my lord. I have
petition
stated, my lord, clearly stated, page 9, my last part, my lord.
was withdrawn, stated
No.
one heard for the parties. It will be filed by the petition that we have been arrested. FIR. Where is the FIR?
My lord, FIR, our impugn FIR, my lord, Nectar 3, my lord, page 21, my lord.
FIR dated 1/4/2024. Page 21.
Page 21, my lord.
Whereby. Where? How many persons are there here?
Here, my lord, 3, my lord, another, my lord, 4, my lord.
Whereby the persons are accused of
Here, 4, my lord.
serious injuries. The husband of the informed. Say FIR. Hailakandi PS case number 93 of 2024, section 326 and 34. CD in the matter was called for CD corporates. Court is of the view that updated CD is required to be called for. Accordingly, let the CD be returned and an updated CD be called for. Meanwhile, till the next meeting, petitioners are granted interim bail, subject to furnishing a bail bond of 20,000 of local securities of like amount satisfied by the state authority. The petitioner will appear before the IO within 7 days from today. And on such other date as may be necessary, the petitioner will not move out of the jurisdiction of the IO, of the Suez Substitution without their permission of the IO. Let the matter be set on
23 September.
23rd of September. Interim bail granted will continue till the next date fixed.
Another matter, another 3 family members.
CD is written, huh?
Another, my lord, next, my lord,
Yes,
3 other family members, matter, my member.
same FIR.
Same FIR.
Where is the, it is that page number?
My lord, every number, my lord, 1845, my lord.
1845, where is the FIR?
My lord, FIR, my lord, Nectar 3, my lord, same.
Nectar 3,
My lord,
page number.
page number, my lord, 19, my lord. DPW.
For APT application, my lord, lordship will find the FIR, my lord, at page 9, my lord. May I read? With due respect and humble submission, I beg to state that we both the parties are neighbors. On so and so about 3 p.m. in the afternoon, the above mentioned accused person, having been cutting the informant's boundary length with da lathi etc. weapon in hand, when my brother, namely Sushil Vishwas, obstructed the accused person, then the accused number 2 injured my elder brother with a stick, my lord. I am that accused number 2, my lord, and also attacked severely at head with a da and seriously injured him and fell down. Having noticed the said incident, I, along with my elder brother so and so, went to save my brother. Then rest of the accused surrounded with da lathi and to strike with a spade. My brother Sushil is fighting with death in hospital in a critical condition. My lord, the case was registered, my lord, under section, my lord, 118 within bracket 2, my lord. That is a grievous hurt, my lord. Earlier it is 326, my lord. So the injury report on the case there is a non-bailable section. And another one, my lord, 109 of the BNS, my lord, that is attempt to murder.
Did he receive?
Yes, sir.
Why do you show me the photograph?
Yes, Malmana.
Because Lordship, the photographs are there and some advice slip and the prescriptions are there, but the uh, exact medical report that is not in the case, right, Lordship, to the extent of the injury. Because I have seen somewhere, Lordship, that some of the persons have suffered injuries on their scalp. There is also one photograph, Lordship, where there is stitching in the scalp. And Lordship, all the witnesses and the injured person, they have taken the main allegation is against this present petitioner. He is the main one who there was a scalp injury.
What injury?
In the scalp, there is a photograph also. Lordship. Scalp injury is there. There is stitching in the head. Lordship.
Injury report will
In
be
the
required.
colored photograph?
So, Lordship, if Lordship kindly allows me some time to get the exact medical report, Lordship, because there are a number of injured persons also. Lordship.
You get the medical report.
Lordship.
But we grant him interim bail in the meantime. Let him appear before the IO and get his statement recorded.
Yes.
You bring the updated CD along with all medical reports. But, section 482.
482 of BNS.
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 BNS. BNS. Apprehending arrest in connection with section. Sorry, apprehending arrest in connection with the FIR dated 11/7/2024. It was closed by the informant, but it's of what it was. So, the FIR was received and registered as Duragam with the 4 of 2024 and the section. There was a boundary dispute. The informant and the family members of the informant and the petition. And there was some altercation, but the allegations made in the FIR are false. No such incident. Okay. So, the council that petitioner and the informant, they're relatives.
Relative.
Are relative. With a misunderstanding between the family members, but no such incident has ever taken place. So, therefore, the prayer when it remains considered to be incorporated in the IO. Respect to the investigation which is being carried on. Para Mr. Sharma, APP, that the case diary report, placed before the court, the case diary, but there is a that detailed medical reports are not available.
Not available.
Case diary. He craved leave of the court, called for the updated PD along with the detailed medical report. Accordingly, let the updated CD along with all medical report be called for meanwhile, if the petitioner is arrested, on furnishing a bail bond of 3,000 like a it's satisfactory arresting authority. So, petitioner will appear the IO within 1 week from today and on such other dates as the required, and it cannot move out the jurisdiction of the concerned police station without written permit of the IO. So, the bail granted, adopted the next day based on
23rd
23rd September.
I'm obliged, deeply obliged.
May I please your lordship. Lordship, the pre-bill application, lordship. The allegation is 395 pieces and FIR is 12. And lordship, what happened, lordship? In this case, lordship, 4 persons already arrested by the police, lordship. One Nurul Amin Mondol, Amir Hussain, and another Prashanto as case executive and Tutan Burman driver of the case van. They are already arrested, lordship. But in the FIR, clearly stated that 2 biker, Bon Roberts, snaked the case back from the CE Prosenjit IQ.
So why are you apprehending it?
Yes, lordship. That is the main fact, lordship. The 2 brackets, lordship, they are used my bike, lordship. I'm totally, and they are lordship and Amir Hussain and lordship Nurul Amin Mondol, lordship. They are our neighbor and relatives, lordship. They are came to our house and take my bike, lordship. And that is the main fact, lordship.
If it is your bike, then you will have to appear.
Yes, lordship. They are arrest, lordship, and clearly clear that in the
No, there are 2 petitioners. There are 2 petitioners.
2 petitioners.
Whose bike was it?
Toevam, the owner of the bike, lordship. Clearly stated, para 4 lordship, only clearly
Then why
stated.
is the petitioner number 2 apprehending it?
No, searching me, lordship, please. I don't know,
Both the
lordship.
petitioner.
Lordship.
Why petitioner number 1 is the owner of the bike?
Bike, yes, lordship.
What about petitioner number 2?
Petitioner number 2, lordship, totally innocent, lordship. Apprehending arrest, lordship, please searching me.
No.
I'm totally innocent, lordship.
No, it's all right, but are they members of the same family?
No, lordship.
Then?
And lordship, it is clearly 2 bikers, lordship. And they are come from the,
Lordship, may I-
which bike? This is the my bike, lordship. I'm clearly, for this, para 4, lordship, I'm clearly stated.
Why did you lend your bike?
Lordship, in this clear lordship, I'm stated lordship. The actual fact of the case is that,
Did you lodge an FIR after the incident?
no, lordship, I approached the police station, lordship. I submitted all documents, bike documents, lordship.
Yes.
Here, Lordship, if Lordship kindly comes to the FIR for a moment, I will just try and explain, Lordship. Page 12, Lordship will see that the vehicle, it was accompanied by CE Prosenjit 8, that is
Yes.
case executive.
Yes.
Then Lordship, gunman Rajiv Rai and driver Tutan Borgon, Lordship. Now, what has happened, Lordship? The total amount is already mentioned, Lordship. It is 34,51,816. Lordship, on that day, on Lordship, the date of occurrence, Lordship has already seen how it was planned, Lordship. 2 persons came in a motorcycle, snatched the bag, Lordship. Now, Lordship, when the investigating officer, Lordship, collected the CCTV footage of the previous days also, Lordship, it was noticed that, Lordship, on 21/6/24, just a few days before the incident, similar 2 persons accompanied in a bike, Lordship, with a helmet. They were on the opposite side of the road and they saw this Lordship, gunman, Lordship, I'm sorry, Lordship, CE Prosenjit 8, making a signal to those 2 persons and signaling them not to come. So, Lordship, thereafter, Lordship, it was deducted, Lordship, that these 2 persons are involved. So, Lordship, this CE Prosenjit 8 and driver, they were arrested. And when they were interrogated, Lordship, all the facts came up, Lordship, that altogether 5 persons are involved, Lordship, including these 2 petitioners. The number 1 petitioner, Lordship, his bike was used. He is fully involved. Second petitioner, Lordship, he was on the bike with another person by the name of Amir Hussain, who is absconding. Now, subsequently, who was absconding, but thereafter he was arrested.
These were the persons snatched.
Yes.
And who is Nurul Amin?
Nurul Amin was one of the rider along with the petitioner number 2. Those 2 were the bike riders who snatched. Petitioner number 1 is the owner of the bike. And for that purpose, Lordship, petitioner number 1, the owner of the bike, received 1.5 lakhs. And petitioner number 2, who was the perpetrator of the bike, Lordship, he received 10 lakhs. Altogether, Lordship, certain amount has been recovered, but around 15 lakhs are yet to be recovered. Arrest is going on, Lordship. These 2 petitioners are needed, Lordship, for the investigation.
Yes, lordship. In this case, lordship, forwarding report, it is clear, lordship. Total amount of rupees 31,51,816 rupees. And from 2 persons, lordship, one Nurul Amin Mondal, Prosenjit I, Tutan Bormon. From those persons, lordship, already amount of rupees 21,52,000 already recovered from 3 persons, and 5,50,000 rupees recovered from one Amir Hussain. And total amount of rupees 27.
From where did you get all that information?
27,02,000 clearly in the forwarding report, Lordship.
Forwarding report?
Yes, Lord.
Where?
Page
34
14.
lakhs.
Page 14, Lordship.
Yes.
Here. Ground of error. Total case of rupees 21,52,000 rupees have been recovered from the possession of the accused person. Yes.
Then?
That is, Lordship, from Amir Hussain.
No, it
It
does
is
not
the
say.
ground of
It does not say
arrest,
that.
Lordship.
It says this was recovered from the arrested accused person.
Yes, Lordship.
He is
And
reading from a
Fatla,
different forwarding.
15 lakh rupees from Amir Hussain. It is the forwarding report, Lordship. And I am not
This is
annexed.
another forwarding report
Yes,
not annexed to the petition.
Yes, Lord.
Another forward.
Who is Amir Hussain?
Amir Hussain is Lordship, one of the bike riders, Lordship.
How many persons were on the bike?
Two, Lordship. Petitioner number 2 and Amir Hussain.
And who is Nurul Amin?
Nurul Amin is Amir Hussain, Lordship.
No, Lordship.
No,
No, Nurul Amin, no. Nurul Amin, the another person was the
Nurul Amin Mondol.
Yes, Lordship. And Amir Hussain.
Amir Hussain, bike rider.
And
Amir
two
Hussain is bike
persons
rider.
in the spot clearly it is Lordship.
Amir Hussain is
And
the
two
bike
persons
rider.
was arrested.
Nurul Amin is another involved group. He is also one of the accused.
No, Lordship. It is the clear in the forwarding report, Lordship. Two persons already arrested. They are riding the
No,
Right.
alright,
No, no.
the number one is the owner of the bike.
Bike.
Yes,
Why is
Lord.
the number 2 apprehending it? How is he connected?
Lordship. Police is searching me. I'm
Why?
sorry,
Why?
understand, Lordship.
Why will they search? Must be some reason for that. What does your CD reveal? What is the stage of investigation?
Lordship, these two petitioners are yet to be arrested along with one more co-accused, Lordship, and the around 10 lakhs are yet to be recovered, Lordship. And already it is, I have already indicated, Lordship, the petitioner number 1, he received 1.5 lakh. The petitioner number 2, he received around 10 lakhs. And they were actively involved, Lordship. They made an attempt a few days prior
Against these petitioners, what material do we have?
against, Lordship.
This petitioner, number 1
Yes, Lordship, they
is
have,
the owner of the bike.
yes.
Then?
All the co-accused, Lordship, they have revealed the conspiracy, how it was done. The case executive, Lordship, and the driver of the vehicle, they have made that plan with all these persons, Lordship. They conspired to make the robbery on 21/6, Lordship. But on that day, somehow, Lordship, they could not, the gunman who was accompanied in the vehicle, Lordship, he was not in the conspiracy, Lordship. So because the bag was in his hand, he signaled that not today, on some other day, Lordship. Thereafter, on that day, it was made, and these two persons are actively involved, Lordship, from the statement of all the co-accused, Lordship. That is apparent, Lordship. So let them, at this stage, Lordship, it may be rejected, Lordship.
And
Around 10 lakhs are yet to be recovered, Lordship.
no, Lordship, it is a very clear, Lordship.
If Lordship kindly
Total
goes to the statement
amount
also,
of
Lordship.
and recovered already clear, Lordship, in the forwarding report, Lordship.
Not the amount.
Yes, sir. But
It's
my
not that
allegation
only
is
the amount is to be recovered, therefore your presence is not.
yes, Lordship. Yes,
Petitioner number 2 is the bike rider, Shahjamal and Amir Hussain. Shahjamal is the petitioner number 2.
And Lordship, highly cooperate with the investigation agency, Lordship. Totally consider.
Yes, give us the city and
Lordship,
mark
yes, I've already marked, Lordship.
My allegation is I'm not denied the Lordship. I'm not
Not a
the
good
one.
place for bail now.
If Lordship kindly goes to the flag mark driver, I have flag mark, Lordship. His statement, if Lordship kindly peruses, it will be clear, Lordship.
Where do you say petitioner 2 is the bike rider? Right?
Uh,
What is his name?
His name is Shahjamal, Lordship.
Shah?
Shahjamal Ali.
Ah.
It has been stated by the co-accused also, Lordship.
Heard. Learned. Repeatedly failed. By petitioners 1 and 2. Apprehending arrest.
Kokrajhar case.
Yeah, fired. Dated 26th of June 2024. Lodged by State Format 1, Lieutenant Colonel Deepak Nandar. In the same prior to that the that an amount of rupees 34,51,816 in cash, which was required to be deposited in the Axis Bank in the Tengapara Kokrajhar branch of Axis, and which was to be deposited into a branch by the cash executive of the company, namely Rupen Singh AICH, along with gunman Rajiv Roy and the driver of the van, Bhutan Burman. As the amount was in the process of being deposited, was being carried to the bank for being deposited. They were snatched away by motorcycle board. Person stop. During the course of the investigation, 3 persons were taken into custody, namely the cash executive, Sanket Pai, the driver of the van, the then Sultan Burman, and one Abdul Hamid Mondal. So, the present petitioner apprehend arrest connected with the alleged offence. However, they submitted that they are not at all connected to the offence with the arrest. So, on account of one, the owner of the bike, which is alleged to have been involved in the offence, the same offence. Petitioner number is also apprehending arrest for reason beyond his comprehension. So, both the petitioners submitted there. It is submitted on behalf of both that they are not connected with the alleged offence. So, there are seen in the matter or an APP that the things are not held. So, after careful perusal of the scheme, we see that there are material, but the matter is still in investigation. Charges is not filed. So, during the investigation, there is a people that present in the scene like that the petitioner one not being not only the owner of the bike but also involved in the other conspiracy to illegally snatch the amount of rupees 34,51,816 belonging to the Radiant Radiant Cash Management Services Limited. Which was required to be deposited in the issuance of branch of the Axis Bank. So, further material in the scheme reveal that there are cash shares paid the petitioner number one for the owner of the bike involved in the alleged offence. So, petitioner number, there are materials to prove that the number was one of the riders, the bike which snatched away the state amount. So, the other rider, the bike, already in custody. One, Guru Hamid Mondal. Considering the state of investigation available, the city which clearly implicates the petitioner at this stage. The material incriminating clearly is prayer for bail, anticipated bail at this stage, and bail petitions that CD return.
Their lordship 120B and 395 was added to.
It's submitted by the internal APP that subsequently 193,
120B
120 capital B
and 395.
395. So that is it.
Right. Yeah, please. As per office note dated 28 August 2024, LCR is received.
LCR is
LCR is received.
received.
Can I fix it for admission here?
Or maybe fix for admission hearing.
As per office note dated 28/8/2024, scan copy of the LCR call for a seat accordingly this petition be listed for admission along with this scan copy. After a week, on a date to be fixed by the registry.
Will you allow the interim to continue?
Interim order passed earlier will continue. Then we fix a date, you give us a date.
Then Lordship,
16th,
Lordship.
16th September. Interim order continue till the next date.
Item number 14, Lordship, service has not been completed.
May bill Lordship. In this case, my lord, so many times take steps, my lord, as well as my lord.
On
My lord, 10/8/2023.
no steps on whom?
Respondent number 2, my lord.
Respondent to who is the respondent to?
Informant, my lord.
So you serve a copy in terms of the judgment. You serve a
Deepak-
copy on the APP.
Yes, my lord. Deepak Nayak is as per order dated, my lord, 10/6/2024, my lord. Step taken as per judgment of the Deepak Nayak, my lord. Office note, my lord.
You have submitted. You have
We have
furnished it
sent
to the-
the notice, Lordship, but it is not, report has not been received, Lordship.
You call for the report immediately
My lord, moreover, my lord.
from the OC. You call for the report. You have sent it to the OC.
Lordship, we will send it.
In terms of the earlier order dated 5/6/2024, steps have been taken by the petitioner, the office of the APP, Government of Assam, and who in turn submits that the same has been forwarded to the concerned police station to be served on the respondent number 2. Stop. However, learned APP submits that the report of service has not yet been received from the concerned station. So let the OC of the concerned police station submit a report in respect of the steps in respect of service of notice on respondent number 2, namely the mother.
Yes.
Mother of the victim.
Victim, my lord.
The victim.
Yes, my lord.
Victim itself.
No. Here is a Shafia Khatun.
All right, respondent number 2. Let the matter be listed again on 16,
17 or 18, 18 or
18th September. Yes?
Yes.
List accordingly.
This report is awaited, Your Lordship.
What
And
is awaited?
scan copy of report is also awaited. But then, Your Lordship, I pray for a stay of the proceeding, Your Lordship, because already 3 days have gone by, and the High Court is disinclined to give adjournment, Your Lordship. That's why the order is necessitated, Your Lordship. At least until the appearance of the,
Anyone for the respondent?
no, because
Service is
certificate,
uncompleted.
Service not complete.
no,
We are not the party, but
This is a DV matter.
DV matter, yeah.
How have you taken steps?
On the last occasion, it was directed by the Honorable Court to send the process to usual procedure. Court. And that was done, Your Honor. There's a report of the registry of Lordship.
Office note dated 30/08/2024 reflects that service report on respondent number 1 has not been received back. Stop. The scan copy of the case report of this within bracket DB case number 20 is called for from the court of the special judicial magistrate Kanpur Metro has also not been received.
Second is the next date.
The
fixed, Your Honor.
petitioner will take fresh steps on respondent number 2 at the appropriate address by registered post ID. You take fresh steps.
But then Your Lordship, stay order is required.
So first you take fresh steps.
Because the next date is on Monday, Your Honor.
The considering the submissions of the council, further proceeding in case number so and so pending before
239 of
judicial magistrate will remain stayed. Matter is listed again on 23rd of September.
In the meantime, I'll take steps now.
So you take steps within 3 working days.
All right.
Steps to be taken by registered post within 3 working days.
Hello.
May I please, Your Honor? Lord, in this case, the service is complete, my lord. Because the all the informant do not have entered the evidence.
Scan copy call for has not been received.
Yes.
Then respondent 19 also service not complete.
But he, my lord, Palatama has been filed on his behalf.
Huh? On
On
19?
P. Palita has, my lord,
For 19?
no, he's 16. Palita is 16. 19.
19 is not here. Wakalat number is for 2, 3, 4, 5, 6, 7, 8,
To
9,
18.
10, 11, 12, 13, 14, 15, 17 and
Yes.
18. 16. Yes, 16 is also there. But 19 is not here.
Then I have to take.
Await service report on respondent number 19. A reminder also be sent for calling of scan copy of the case records of PRC number 28 of 2020 from the court of JMS Poco. Stop. Meanwhile, the other respondents, namely respondents number 1 to 18,
Yes, ma'am.
are represented by the respective counsel. You want to file any objection?
Yes, I will file.
The councils are permitted to file their objection in the matter within a period of 2 weeks from today.
Yeah.
This can after 2 weeks on a date to be fixed by the registrar.
Lord, the proceeding is continuing before the learned court. My lord. So may I prefer, Lord? In the meantime, I'll take the step. But the LCR has
What step? You have already taken step, directing press step, saying await for the service. What is the stage of the proceeding?
that is on the consideration of success. Charges are not yet made. The party are to appear before the learned.
You file your application properly. The interim order is not granted here.
Not
Then
earlier, not granted.
not granted.
Therefore, I am praying before.
You can't pray like that. You must have prayed on the first day. Did you not
In fact-
pray?
In fact, that was done in lordship. It is not reflected in the order,
Not reflected
but
in the order.
the opinion of the court.
So you have to file a fresh application for stay.
I will file with that.
Lordship. I'm sorry, Lordship. Item number 12, Lordship. I may be wrong, Lordship, but I think I heard Lordship dictating that the bike rider was Nurul Amin and Shahjamal. It should be Lordship Shahjamal, that is petition number 2, and Amir Hussain. Bike rider.
Shahjamal and Amir.
I may
You
be-
you give the city also.
Lordship.
You mark that portion.
Lordship.
I think it is in the statement of the driver.
Statement of Nurul Amin Mondol, it will clarify everything, Lordship.
Right. You mark it and
Lord.
put it.
I may be wrong, Lordship, but I think I heard.
No, perhaps you are correct
Lordship.
because the names are very
Yes,
similar.
yes,
So
Lord. That is all.
you kindly give the city.
Yes,
We will get it back
Lord.
along